Hello and welcome to Narayana Eyes. I'm Pratik, faculty for Polity, International Relations and Security. Students, yesterday we discussed 8 topics under the theme Parliament, State, Legislature and Local Government. I hope you understood all the topics that we discussed yesterday, and at the same time I hope you downloaded the notes of the topics that we discussed yesterday for the sake of revision. Please students, make sure that you are revising each and every topic that we discussed. Do not delay the revision work because this will cost you a great time. So make sure you are revising it on the same day itself by downloading the notes from the description. I hope you are doing that, and I hope you also understanding the topics that we are discussing. In case you have any doubt, any questions, I request you to please ask in the comment section. Do not hesitate to ask any question, right? And the topics that we shall be discussing today are the topics under a new theme. The new theme being the center and the state relations, right? But before we begin, I have an announcement to make. So Narayana is soon will be launching 1 year and 2 year prelims cum mains integrated program. So all those students who are interested to be a part of a 1 year and 2 year program, please make sure to scan the QR code available on your screen and fill in the necessary details. Our team shall get back to you with all the required information. Make sure you enroll yourself in the 1 year and 2 year prelims cum mains integrated course, because this will teach you a lot, right? I'm pretty sure if you attend your 1 year and 2 year program, and the way we have designed our courses will ensure your success in the UPSC examination. Make sure you're part of it. Make sure you're a part of this amazing journey, and make sure you ensure your success. Why? Because please remember the goal. What is the goal? The goal is to serve the country. And how do you serve the country? Bureaucracy is not the only way to serve the country, but through bureaucracy you get power, and through power you can change the lives of so many people who are in need of honest officers working for the welfare of people. So make sure you subscribe to the course, be a part of this journey, and ensure your success. On this note, let us begin. As I told you, the new theme that will be starting today is the center state relations, and these are the 7 topics that we shall be discussing in today's lecture. The first topic is the financial devolution of states. So, of the money the center collects in the form of taxes, what percentage the center shares it with the states. The second topic talks about the concept of special category status. So, Andhra Pradesh is demanding this status, and so you'll understand the concept of special category status. The third topic will understand, which is the state's power to tax minerals. So in this topic we shall be discussing the 7th schedule of the Indian Constitution. The fourth topic talks about Kerala's net borrowing ceiling, and the fifth topic talks about again the 7th schedule, that is regulation of industrial alcohol. The sixth topic talks about internal emergency. We'll discuss the different types of emergencies. And the 7th topic talks about the concept of formation of new state, which is under Article 3 of the Indian Constitution. So these are the 7 topics that we shall be discussing today. Make sure you're fresh, you have a pen and paper to jot down the notes, and make sure you remain fresh so that you understand each and every topic. It's my duty to ensure that you understand each and every topic that we shall be discussing, and it's your duty to jot down the running notes and ensure you're downloading the notes of these topics, and also you revise each and every topic. On this note, let us get started with the first topic. The context being, recently several states, especially the states in the southern part of our country, have raised concerns that they are not receiving a fair share of tax revenue from the central government. Now, these concerns relate to how the divisible pool of taxes is distributed between the center and the states, which lies at the heart of India's fiscal federalism. Right? So this is the context. If you're not understood the concept, it is completely fine. We'll understand each and every term and then we'll understand what exactly is the context, right? So let us start with the basic concepts. Now, why are we discussing this topic? Because questions related to this topic are asked in the examination as it was asked in the year 2014 with a reference to the 14th Finance Commission. You may wonder why are we discussing 14th Finance Commission with respect to this topic. We'll understand in some time, so please be patient. Now, first and foremost, we'll understand what is divisible pool of taxes. What is divisible pool of taxes? Now, the divisible, this term, it refers to the net tax revenue collected by the union government. Net tax revenue collected by the union government, which is then shared between the center and the state government, which is then shared between the central and the state government as per Article 270 of the Indian Constitution. As per Article 270 of the Indian Constitution. Which means, let's say, people in our country are working in different states, so they pay income tax. This income tax is collected by the central government, right? Which means the central government is collecting the taxes and this money the center collects has also to be distributed among the states. So here we see a sharing agreement between the center and the state. So this sharing agreement reflects cooperative federalism. What? Reflects cooperative federalism of India, which means where both the levels of government, the center and the state, they rely on one another for financial resources. Which means the central government collects money and this money is distributed among the states. Of course, the state government also imposes taxes. But here the central government is also imposing taxes, collecting money, and this money is actually being shared among all the states. Now, taxes that form part of the divisible pool, for example, corporation tax is something that gets shared. Personal income tax, the example that I just gave, GST, goods and service tax, then the center's share of integrated GST, we have center GST, the state GST is collected by the state. So, under GST, we have the central which is collected by the central government, state which is collected by the state, and integrated GST again the center collects. Now please remember that these taxes are shared based on the recommendation of the Finance Commission. That's the reason we discuss a question on Finance Commission. Finance Commission, what is it? It's a constitutional body set up every 5 years under Article 280 of the Indian Constitution. So what the Finance Commission does is it studies the financial needs and capacities of both the central and the state government. It studies the needs and capacities. Based on that, it recommends how the divisible pool should be split between the center and the state. Now, in addition to the tax shares, the states also receive grants in aid. The state also receive grants in aid from the central government. Again, this grants in aid is provided to the states based on the recommendation of the Finance Commission. And these grants are often meant to address specific gaps to promote equitable development. Let's say there are few states which are not economically as advanced as the southern states. So the states which are not economically advanced, the Finance Commission recommends these are the challenges a particular state, let's say like Bihar is facing, and that's the reason the center has to give more money to Bihar. Now, however, it's important to note it's important to note that not all the taxes collected by the center are shared with the states. Of all the taxes the center is collecting, not each and every tax is shared with the states. For example, taxes such as cess and surcharge, which are levied for specific purpose, let's say for example education, or let's say for infrastructure, roads, railways, they're excluded from the divisible pool of taxes. They're excluded from the divisible pool of tax, and this actually is a major concern for states. Why? Because these collections from cess and surcharge have significantly increased over the years, and thereby this is actually resulting in reducing the actual size of the pool that is shared with the states. So this is a major concern the states have highlighted. I hope you understood what exactly is a divisible pool of taxes. Now let us discuss about the Finance Commission and its role. Now talking about Finance Commission, right? Finance Commission is set up every 5 years and is responsible for what? To make recommendation on the financial, to make a recommendation on the financial devolution. Now who appoints it? It is the central government that appoints it. It consists of a chairman plus 4 members. Consists of a chairman and 4 members, all are appointed. Who appoints? Again a question for prelims. Appointed by the President of India, and the qualification of the chairman and members is defined under the Finance Commission Miscellaneous Provision Act of 1951. Now question on the latest commission, right? Which is the latest commission? Such questions are asked in the examination. The latest commission, which is the 16th Finance Commission, was appointed again. The members were appointed by the President, and this commission was constituted under the chairman of Dr. Arvind Panagria. And this commission will provide recommendation for the time period between 26 and 31. So it's working on the provisions, and the recommendations that the Finance Commission will give will be applicable from 26 to 31. This is the Finance Commission and its role. I hope you understood the Finance Commission and the role of Finance Commission. Now let us try to understand the basis of allocation. We have discussed that the center is actually sharing the taxes with the states. But the question is, does each and every state get an equal portion of share? No. Now, please remember the Finance Commission recommendations, right? They are followed, or they are followed for both the vertical devolution as well as the Finance Commission recommendations, right? The recommendation it provides is followed for both vertical devolution and horizontal devolution. It's the same like vertical reservation and horizontal reservation. What is vertical devolution? Which means how much of the total divisible pool is given to the states combined. And horizontal devolution, which means how much of the amount is divided among individual states. Vertical reservation given to different categories. Within that category, how much reservation is given to one specific group in that category. That is horizontal reservation. It's same. Let's Understand this with the help of an example. Let's say the center has collected 100 rupees in the form of taxes. Now vertical devolution, which means let's say the finance commission says that of the 100 rupees you have collected, you need to give to the states how much? 40%, that is let's say 40 rupees. Now this 40 rupees has to be shared with all the states. But does that mean that this 40 gets equally divided with all the states? No. No. That's the reason this recommendation is again given by the Finance Commission. As per the 15th Finance Commission, the 15th Finance Commission, right? The vertical devolution has been fixed at 41%. 41, which means that 41% of the center's net tax revenues are to be shared with all the states collectively. With all the states collectively. So, of the 41 percentage, now comes horizontal devolution. For horizontal devolution, the Finance Commission uses a set of criteria. This can be asked for your prelims examination. This can be asked for your prelims examination, and which are the set of criteria. For example, population of a state is taken into account, area, forest cover, income, distance, demographic performance. So these are the criteria that are considered by the Finance Commission. Based on these criteria, the Finance Commission will recommend how much a state is to get of the 41 percentage given to the states. I hope you have understood this. Now please remember these criteria. These criteria determine how much each state gets from the total state share. Now the southern states, they argue that although they have performed better, for example with respect to population control and development, these factors may not be rewarded fairly or may not be rewarded fairly under the current formula, which is this. And this leads to demands for reform, which means southern states, they demand that these criteria should be reformed. For example, here you can see in this, these are the criteria. What is income distance? The gap between a state's per capita income and that of state with the highest per capita income. This is what we understand by income distance. Now, the description, the meaning of each of these criteria can also be asked in the examination. Now, population, these terms are relatively easy. Income distance at times can be confusing. So, what is income tax? The gap between a state's per capita income and that of the state with the highest per capita. And what is the purpose? To provide more resources to states with lower per capita income. So these are the criteria. The meaning population, again very simple. Now the population figures is based on the 2011 census. Forest and ecology, demographic performance in controlling population growth. So these are the factors, and the purpose behind these factors is southern states want these factors or these criteria to be reformed. Let us focus on the second topic. The title of the second topic is Special Category Status. Now, Andhra Pradesh has demanded special category status, right? And this demand from Andhra Pradesh has gained momentum, has gained national attention. Especially, this has to be understood in the context of the Telugu Desam Party, right? The government in Andhra Pradesh, which is a coalition partner in the NDA at the center. Now, given that TDP, led by Chandrababu Naidu, has extended support to the central government, the state now demands special category status for the state. But now, see, when it comes to special category status, right, such type of questions are asked in the examination. For example, which of the following was given classical language? So, which of the following states were so far given special category status? Such questions can be asked. That's the reason studying and understanding such topics, it becomes important for the examination. Now, what is special category status? Let us try to understand this term. Now, special category status is a classification, and this classification is granted by the central government to states. The states that face geographical challenges and socio-economic disadvantages. When the states face these kind of challenges, then the central government may grant special category status to such states facing these challenges. Now, for the first time in the year 1969, right, this concept was introduced with Jammu and Kashmir, Assam and Nagaland. These were the three states who got the benefit under the special category status. Over the years, a total of 11 standards have been given special category status, and these are the 11 states that got the special category status. And currently, it is the Andhra Pradesh, Bihar and Odisha. These are the three states who are demanding special category status, which means a state or few states face certain kind of challenges. In response to these challenges or because of these challenges, a state is finding difficult to grow or develop. There's a reason it demands special category status. Now, when it comes to parameters for granting special category status, right? Now, please remember that the parameters for granting special category status was defined by a committee known by the name Gadgil Committee. Gadgil was a former economist, and during the third year 5 plan, that is between 61 to 66, Gadgil defined the parameters to grant special category status. And which are the parameters? One, geographic challenges, that is hilly and difficult terrain, low population density or sizable tribal population, strategic location along borders or international borders, for example, the bordering states like Arunachal Pradesh, Uttarakhand, economic and infrastructure backwardness, and non-viable state of nature of state finances. So again, I request you to please remember these key parameters because these parameters are important for the examination. Make sure you remember these parameters, the name of the committee, because this can be asked in the examination. So the criteria for identifying special category status, right, as I told you, was defined by the Gadgil committee. Now the formula was designed to ensure fair allocation of central fund to states, especially those states facing development disadvantages, let's say like Bihar, Jharkhand, Chhattisgarh. So the question is, what are the benefits of special category status? If a state gets this category recognition, then which are the benefits? Now, the states that we discussed that was granted special category status, they enjoy many benefits. For example, one is the higher central funding, which means for centrally sponsored schemes, see, there are two types of schemes. One is central sector schemes and the other one is centrally sponsored schemes. Now, these schemes, the funding for these schemes is shared between the center and the states. Now, for centrally sponsored schemes, right, the states receive 90% funding from the center. So, states having this special category states get 90% funding. For example, for states not having this status, let's say there's a scheme called XYZ, let's say uh, Pradhan Mantri Ayushman Bharat scheme, right? Ayushman Bharat scheme. When it comes to centrally sponsored scheme, right? Let's say the amount gets divided 60 is to 40 for normal states, which means 60% funding for this scheme will be given by the center, 40% will be given by the state. 40% will be given by the state. But for states having special category status, this amount will increase to 90%, and the special category state, that state has to only contribute 10%. This is the benefit. Then the next one is fund utilization flexibility. Now, the unused funds at the end of the financial year does not lapse and can also be used in the next year. For normal state, if the funds remain unutilized, it lapses. But for special category states, it does not lapse. Next is tax concessions, which means that the special category states, they receive relaxations in certain types of taxes. For example, excise duty, custom duty, income tax, corporate tax, as compared to other states. Why? Because having less tax, which means there will be more investment. More investment will lead to more industrial growth, more employment, more demand and supply. This is how the economy grows of a particular state. And then priority in the central budget allocation. Now these states get a larger share of central funds, and this actually supports the infrastructural and, let's say, the social welfare projects, which actually leads to results in growth in a state. I hope you understood the benefits of special category status. Now let us try to understand what the Finance Commission has to say on the special category status. Okay. Now, the 14th Finance Commission, it took a strong stand on this particular issue. It recommended that the special category status should be discontinued for all the states except for the northeastern states and the hilly states like Uttarakhand. Instead, it proposed that increasing the tax devolution from 32% to 42% of the center's tax revenues. This can be a possible solution to address the financial needs of states that require more funding. And this shift, the purpose of this shift is aimed to promote a more uniform and transparent system of fiscal federalism without creating preferential classifications. The purpose is more uniform and transparent system, and this actually helps the concept of fiscal federalism as well. So, see, this debate around special category status, it reflects tensions within India's fiscal federal structure. The southern states have a problem. The southern states have, in the last few years, in the last few decades, the southern states have performed better than the North Indian states. But they are not getting the benefits, which means actually the southern states feel, or it's also a fact that the southern states are being penalized for development, which means the southern states have actually contributed to the growth of our country. Instead of giving benefits, the southern states have to pay more money to the center in the form of taxes. And the states that are not performing better relative to the southern states are getting benefits years after years. Which means the states who not perform well, you should punish those states so that they can perform better, but instead you are continuing to extend the benefit to the less developed states. So no doubt the more funding to less developed states have helped certain states overcome the development barriers, but expanding or reviving it for other states could also pose financial challenges. And please remember that this issue is very, very political sensitive. Why? Because it also depends which government of which political party, whether it's a part of the government at center or whether it's part of the opposition. So let's say, had Telugu Desam party been in the opposition political party, let's say the Congress, supporting the Congress faction, then their chances of being recognized under the category of special category status would be bleak, would come down, would become narrow. I hope you understood the topic. Let us move on to the next topic, that is the state's power to tax minerals. Now, the Supreme Court recently reversed a 1989 judgment and confirmed that the states have the authority to impose taxes on mineral rights. This decision actually distinguishes the difference between royalty and tax and redefines the financial powers of states and center in regulating minerals, which actually falls under the 7th schedule of the Indian Constitution. Again, questions on, questions have been asked in the examination, right? So it is important to discuss this particular topic. Now, first and foremost, let us try to understand the difference between royalty versus tax. See, royalty is a payment made based on an agreement between two parties. Two parties. Which means it is given as compensation for using certain rights or let's say benefit. Especially in this context when the benefit is with respect to using natural resources. Now this payment, the payment that is made is based on the benefit the person, that is, it is also referred to as the grantee, gets and is seen as part of the contract. Which means, let's say I'm a company, I'm using, let's say, natural resources in a particular state. Against the use of the resources, I'm paying royalty. And the courts have clearly said that royalty is not a tax but a payment for using resources. Royalty is not tax. Which means royalty is not a tax, it's a payment that you are making for using certain things. In this context, it is the natural resources. Tax, on the other hand, is a compulsory payment levied by the government for the public purpose. Simple. There is no benefit as such to the taxpayer. In fact, it's a burden on the taxpayer. And the Supreme Court rulings have confirmed that taxes are not connected to the privileges and is mandatory. Each and everyone has to pay the taxes. So tax is something that is mandatory. Now, in this context, let us try to see what the Supreme Court has to say. There are three judgments that we need to understand. One is the 1989 judgment, the other one is 2004 judgment, and the latest being 2024 judgment. Now, in the year 1989, a 7-judge bench held that royalty was a form of tax within the meaning of Union List and the Mineral Mines Development Regulation Act 1957. In the year 1989, 7-judge bench of the Supreme Court said that royalty is also a form of tax. And it also concluded that states could only collect royalties and not levy additional duties. Additional taxes, the center will levy it, the states can only collect royalties. Why? Because this ruling of the Supreme Court was based on the understanding that the mineral regulation falls under Union List, which means the central government can only levy taxes. Mineral regulation it falls under Union List, which means only the central government can levy taxes, states can collect royalties. And that's the reason it's also a form of tax. This is what the Supreme Court opined in the year 1989. In 2004, a 5-judge bench pointed out a possible error in interpreting royalty as a tax. In the year 2004, the Supreme Court said that there may possibly be error in the interpretation what the Supreme Court thought in the year 1989. And finally, in the year 2024, a 9-judge Supreme Court bench overruled the 1989 judgment, said that this 1989 judgment is wrong and clarified royalty is not a tax. So again, a question can be asked whether royalty is a form of tax or not. A simple question. And this requires understanding of the recent events. Which means the courts, right, The courts stated that states have full authority to impose taxes on the mineral rights and the entry 50 under entry 50 of state list. Entry 50 of state list, which means state have the right to impose taxes. Parliament can, however, place reasonable restriction. Who can place? Parliament can place restrictions. States have the right to impose taxes, but Parliament has the power to place reasonable restriction to ensure state imposed taxes do not hinder or do not come in the way of the mineral development. Parliament does not have the power to tax mineral right is what the Supreme Court opined recently. Which means, as of the recent judgment, Parliament does not have the power to uh, impose taxes. It is the state who has the power to impose taxes. But a few judges of the bench, they disagreed with this majority opinion. What they said is, or they warned that giving states the freedom to tax mineral rights may lead to actually encroachment on other tax powers. For example, let's say land. One is land, and let's say building tax. Giving power to the state to impose taxes can also lead to encroachment on other tax powers such as land and building tax. They caution that inconsistent taxation, the taxation is not uniform, and if it is inconsistent, it could harm the national mineral policy, or let's say pricing and eventual development as well. That's the reason parliamentary intervention is required, might be needed to preserve uniformity when it comes to taxing the minerals in our country. So this is something that you need to remember. Now let us try to understand the Act. Mines and Minerals Development and Regulation Act of 1957. There are three amendments that you need to remember. One is the 2015 amendment, 2021 and the 2023. So these amendments will help you understand the observation made by the Supreme Court more clearly. Now in the 2015 amendment, first we'll understand what is this Mines and Mineral Act. See, the Mine and Mineral Act of 1957 is India's main law that governs the mining sector in our country. It ensures that the mineral resources are developed responsibly, they're conserved properly, and also the mining activities are carried out in a transparent and lawful manner. The Act also includes the rules of how the uh, mining rights are given, how the mining is monitored, and how the local communities are to be supported. Local communities, especially the areas from where the minerals are to be extracted, because this will affect the local people. So this law deals with how the rights are given, how it is to be monitored, and how to support the local population as well. That's the reason in the year 2015 the government made auctions mandatory for granting mineral rights. The government changed the law to make the process of giving mining rights more transparent, which means from this point onwards, all the mineral rights had to be granted through public auction process. This meant that companies could no longer receive the mine through direct allocation, direct allotment. Mining auction has to be held compulsory. And this goal was to ensure fairness and also to reduce corruption. This amendment also led to the introduction of the district mineral foundation to benefit people affected by mining, and also to set up National Mineral Exploration Trust to support exploration efforts. Now the district mineral foundation, right, it collects a portion of mining revenues and uses it for health, education and welfare of the mining affected people. So this is what was said in the 2015 amendment. The 2021 amendment, right, it removed the difference between captive and merchant mines. Captive and the merchant mines. Now let us try to understand the difference between captive and the merchant mines. The captive mines are mines that are allowed to extract minerals only for the company's own use. For example, a steel company with a captive iron ore can use that only for iron ore in its own steel plants. It cannot sell the minerals to other buyers. This is what we understand by the term captive minerals. On the other hand, merchant mines are allowed to sell the minerals they extract in the open market to any buyer. These mines operate more like commercial businesses and focus on selling the minerals for what? For profits. So this distinction between captive and the merchant mines was important in earlier mining laws but was later relaxed through reforms. So again, these terms can be asked in the examination. Make sure you know what is the difference between captive and the merchant mine. And finally, in the year 2023, the law was changed to give companies more flexibility in how they use minerals from the captive mines. Under the new rules, the companies with captive mines are now allowed to sell up to 50% of their annual mineral output in the open market. 50%. Please remember this number because statements can be asked in the examination. Now, this change came only after the company has met its internal requirements and it allows for better use of the surplus resources. Now, this amendment also made it mandatory that all mining rights for private players must be given only through auctions, as was said in the year 2015 as well. This meant that no private company could receive a mine directly and had to compete fairly to win a mining block. And this ensures what? Transparency and fair competition across the mining sector. I hope you understood the changes made in the 2023 amendment. Now see, in the year 2023, 6 minerals were removed from the list of 12 atomic minerals restricted to state agencies. This allows the concessions to be auctioned. This amendment, it introduced exploration licenses to attract foreign investment, also to engage smaller mining firms. It recognized the importance of critical minerals like, let's say, lithium, cobalt, then titanium, graphite, and also other rare elements for what? For India's transition to clean energy and net zero targets by the year 2070. So essentially, the Supreme Court's ruling, you see the Supreme Court's ruling, it strengthens the fiscal power of states by affirming or by confirming the right to tax mineral rights independently. Yes, it offers more financial autonomy to the states, but this ruling also brings a responsibility to maintain policy coherence, that is uniformity, so as to avoid discontinuance or, let's say, disruptions in the pricing and investment, and the care has to be taken so as to attract foreign investment, and that for that there has to be coordination between the center and the states so as to ensure the policy remains uniform, and at the same time the mineral sector of our country sees sustainable growth across the country. I hope you understood the topic. Moving on to the next topic, the title is Kerala's net borrowing ceiling under Article 293. Now in 2023, the central government imposed a net borrowing ceiling. Ceiling is limit on the state of Kerala, capping its total borrowing to 3% of its estimated gross state GDP for the financial year. Kerala challenged this cap in the Supreme Court, arguing that such a restriction violates its fiscal autonomy guaranteed under Article 293 of the Indian Constitution. Which means, let's say if the gross state GDP of Kerala is 100 rupees, which means the limit to which they can borrow is 3%, that is 3% of its estimated gross state GDP. Now questions. Again, this also deals with the power of the state. So a related question can be asked, though this question is not directly related, but somewhere topics which are closely related can also be asked in the examination, as it was asked in the year 2015. Now, Kerala's net borrowing ceiling. Let us try to discuss the constitutional framework for borrowing powers. Everyone borrows money. Everyone borrows money. The center borrows, the state borrows. First, let us discuss the borrowing powers of the union, which is under Article 292. The union government borrowing money. Now, the central government has the authority to borrow funds on the security of Consolidated Fund of India, CFI. Which means when we are actually borrowing money, we also need to provide security. The central government should also provide security, and the security is the Consolidated Fund of India, which means it's a treasury of the central government. However, this borrowing is not absolute and is subject to limits that may be set by the parliament. Now, these restrictions set by the parliament are intended to promote fiscal discipline. What? Fiscal discipline. And it also, manages the debt at the national level. So if, let's say, for example, is it possible for someone to keep on borrowing money? There has to be limit, there has to be discipline, fiscal discipline. Every individual has to maintain fiscal discipline. At the same time, the central government also needs to have or maintain fiscal discipline. Same is for the states under Article 293, which means state can also borrow money, and the security that they have to provide is the consolidated fund of that respective state. However, if a state has any existing loans from the central government, let's say you have taken you have taken loan from the bank, can you get another loan? No. So if a state has an existing loan from the central government, it must first obtain the center's permission before taking additional loans, let's say from the international market. Under Article 293, subsection, or let's say clause 4, the center can impose conditions while granting such consent. Which means, actually, if you see here, center is getting power or control over the state borrowing. Which means that this provision allows 293 section 4 allows the union government to influence how much and under what terms a state may raise funds through, or let's say, from borrowing. I hope you understood the borrowing powers under 292 and 293. Let us try to discuss the historical background of Article 293 to understand the current context. Now, please remember that Article 293 evolved from Section 163 of the Government of India Act 1935. This Section 163, it governs the borrowing powers of the provinces under the colonial rule. Provinces are the same like states. That provision included a safeguard. And what was a safeguard? The center could not unreasonably deny or delay the consent to the provinces. And any such dispute would be settled by the Governor General. However, if you see the Constituent Assembly chose not to include this section in the Indian Constitution. Why? Because the Constituent Assembly believed that an elected and accountable central government would act in good faith and will not delay the funding to the states. And that's the reason there is no need for an external check. And here the Kerala government accuses the center to interfere or to affect the financial autonomy of the state. In this context, it is very important to understand the Fiscal Responsibility and Budget Management Act, which was framed in the year 2003. This act, the FRBM Act, it serves as the foundation for fiscal discipline in India. And it applies to both the central government as well as the state government. Again, a very, very important point for your prelims examination. Now, under the fiscal deficit reduction, the Act aims to reduce the fiscal deficit to 3% of the GDP. So, all these numbers are very important. That's the reason I mentioned here. In terms of debt control, the total debt of both the center and state should not exceed 60% of the GDP by 24-25. And the center's own share should remain under 40%. Very important term. These are the very important terms that you had to remember for your prelims examination. The Act mandates the submission of 3 statements with the union budget. One, the macroeconomic framework. The second, the medium-term fiscal policy. The third, fiscal policy strategy. Though this topic is slightly related to Indian economy, but again it's a overlapping topic. The 18th Amendment merged the medium term and the strategy statements into one and introduced medium term expenditure framework statement. Very, very important. As for breach of limits, the Act allows the government to exceed deficit targets only in case of emergencies, but only up to 0.5% of the GDP. So each and every number. So please remember these numbers and the merging of the medium and the fiscal policy strategy statement. Please ensure that you are downloading the notes so that you can revise all these points. So this topic, right, the essence of this topic is that the Kerala's challenge, or the challenge made by the Kerala government under Article 293, it reflects a broader debate about the, let's say, the balance of fiscal powers in India's federal structure. Yes, Article 293 allows the center to supervise state borrowing, the use of borrowing limits, or let's say ceiling, especially in times of economic need. It also raises concerns over the erosion of the autonomy granted to the states by the Indian Constitution. And then with the Financial Responsibility Management Act, right? The FRBM Act, it actually, establishes obligations. It sets obligation that aim to ensure overall debt management as well as sustainability, and these provisions must be interpreted in a way that actually balances one, the fiscal discipline, fiscal responsibility with the development needs of states. So again here, fiscal cooperation is very, very important. This brings us to the end of this topic. Moving on to the next topic, and the title of the next topic is Regulation of Industrial Alcohol. So who should regulate the industrial alcohol? The Supreme Court's 9-judge bench in a 8-1 majority recently held that states have the authority to regulate industrial alcohol. This decision overturns the 1990 verdict, right, which had earlier given the central government exclusive control power over the regulation of industrial alcohol. Again, this pertains to subjects. This topic pertains to subjects under 7th schedule. So questions have been asked in the examination. So here you see 7th schedule. So you should be in a position to attempt the or understand the topic. First and foremost, what is industrial alcohol? Now, industrial alcohol refers to ethanol that is chemically treated called denaturation by adding substances like benzene or gasoline. It makes it unfit for human consumption. Why? Because of the treatment. It is widely used in manufacturing industries such as pharmaceutical, cosmetics, perfumes, and cleaning agents. However, due to its chemical base, the naturation, it can be misused to produce harmful intoxicants. On the other hand, usable or potable alcohol which is used for human consumption does not go through denaturation and is strictly regulated for safety and taxation. I hope you have understood the purpose or what is industrial alcohol. It is chemically treated, used for the industrial purposes, and the alcohol used by the or used for human consumption is different than industrial alcohol. Now the question is, why is there a dispute over taxing industrial alcohol is something that we need to understand. Now see, the legal conflict arises. Why? Due to the overlapping entries or subjects in the Constitution's 7th schedule that actually distributes. What does 7th schedule do? It distributes the legislative power between the union and the states. It decides on which subject the union government can make a law, on which subjects a state or states can make a law. For example, if I talk about the entry 8 of, if I talk about the entry 8 of the state list, it empowers the state list, it empowers the state to regulate intoxicating liquors. Who has the power? State. But if I talk about entry 52 of the union list, it gives a center power over industries. It gives power. This is what we understand by the term overlapping, which means industries including those declared by parliament to be of national interest. Then if I again talk about concurrent list, if I talk about concurrent list, especially entry 33, it gives the parliament the power to legislate on industries for public interest. Public interest, which means when it comes to, let's say, supply and production. Now, because industrial alcohol, right, it falls under industry, and this industrial alcohol is regulated by Industries Development and Regulation Act 1951. The center has actually claimed authority over it. Why? Because it falls under the term industry and is regulated or is mentioned in concurrent list, right? But states, they argue that any alcohol that can potentially cause harm or intoxication should be under the domain of the state, because it is the duty of the state to take care of the people in the state. So any alcohol that actually causes harm should be under the state list is what? Of course, the alcohol for human consumption is under the state list. Industrial alcohol should also be under the state list, because any alcohol that actually causes harm should be under the state list is what the states argue. Why? Because it is a responsibility of a state to look after the subjects of the state. This is the argument the states have given. Now let us try to understand what the Supreme Court ruled, that yes, the power should be with the states. Let us try to understand the argument of the Supreme Court. Now, the majority bench, that is 8 judges of the 9 judges, they ruled that the term intoxicating liquors should not be narrowly defined. Instead, it should include all types of alcohol that can actually cause harm to public health, and not just beverages. The court emphasized that substances like alcohol, narcotics, drugs, opium, even when intended for industrial use, they have the potential, let's say, for misuse. Therefore, it actually supported the state's right to regulate the industrial alcohol to protect public health, because health falls under the state domain. The court also clarified that parliament cannot override a state's constitutional authority over intoxicating liquor. Just by declaring, let's say the state can, the center can actually declare any industry to be of national importance and can keep the power. And this broader interpretation of the Supreme Court of intoxicating also meaning poisonous. So here the court interpreted the meaning of, let's say, intoxication as something that is very, very harmful or poisonous, and that's the reason it allowed the state to regulate industrial alcohol as well. And then the judge that actually dissented, out of 8, one judge did not agree with the majority judge. The The lone judge, the sole judge, argued that letting states to regulate industrial alcohol could confuse the original legislative purpose of the constitutional entries. What is the original purpose? The original purpose, or rather, the judge held that this judgment of Supreme Court could blur the boundaries between powers of the center and the states, and this can actually lead to complication. This can actually lead to complication, and that's the reason uh, the lone judge disagreed with the majority judge opinion. The next topic talks about internal emergency. The year 2024 marks the 50th anniversary of the declaration of internal emergency, which was declared on June 25, 1975. The emergency was not triggered by any real internal threat, but mainly by political instability and insecurity within the government. So questions on emergency have been often asked in the examination, as it was asked in the year 2018. So let us try to understand what exactly is emergency, right? Now, emergency in India, right? It actually refers to a special situation when the democratic functioning is suspended. Why? Is suspended so as to deal with national security, let's say unity, or let's say governance. And this concept of emergency has been, has been taken, drawn inspiration from the Weimar Constitution of Germany, again important point for your prelims, and is provided under Article 350 to 360 of the Indian Constitution under Part 18 of the Indian Constitution. So when the security of a country is threatened, or when the stability of a country is threatened, then the emergency power can be invoked, and it's mentioned under Article 352 to 360 of the Indian Constitution. So of course, there's a difference between internal emergency and external emergency. When it comes to internal emergency, is a situation where the democratic rights are suspended, which means the fundamental rights are suspended, and here the state governments, or the power of the state governments, is actually falling in the hands of the central government. There are no civil liberties. The press is heavily censored, and the political opponents are often, let's say, put under house arrest. Now, when I talk about the 1975 situation, the immediate trigger for the imposition of emergency in the year 1975. Why? Because the 1975 emergency was declared because of internal, let's say, emergency or internal threat. The Allahabad High Court in the year 1975 declared the election of Prime Minister invalid or void, and just 2 weeks later, emergency was imposed. And then, in order to criticize the emergency, Jay Prakash Narayan, a towering figure in Indian politics, he launched Sampurna Kranti, that is total revolution, and found huge support across the country and criticized heavily the imposition of emergency. And the way the powers were taken away from people, the fundamental rights were suspended, later was restored by the judiciary, especially when the judiciary upheld the fundamental rights under in the Golaknath and the Kesavananda Bharati judgment. Now, to suppress the opposition, right, the government actually used the Maintenance of Internal Security Act 1971, and it actually was a preventive detention law that allowed for the arrest of leaders, especially from the opposition, without trial. We discussed detention day before yesterday. This was a law which was framed in the year 1971 to suppress dissent. So in short, external emergency, which means when the emergency is imposed because of, let's say, war, or let's say external aggression. internal emergency is imposed because of the internal situation which is disturbed because of any reason. It can be political instability, opposition from the government, opposition from the opposition political parties. Now let us try to understand the types of emergency: national emergency, president's rule, financial emergency, 352, 356 and article 360 of the Indian Constitution. Now, national emergency, which means it is declared when the security of India, not the entire country, but any part of it is, let's say, is disturbed by war, external aggression, or armed rebellion. National emergency was imposed three times so far. One, during the 1962 war with China. The second one was during 1971 war with Pakistan. Third one was during 1975. First two emergency was declared because of war. The third was declared because of internal disturbance. And after the 44th Constitutional Amendment Act, because the word internal disturbance was misinterpreted, that's the reason the 44th Constitutional Amendment Act, it replaced the word internal disturbance with armed rebellion to provide more clarity on the grounds on which emergency can be imposed. Then the president's rule under 356, which means this is also called state emergency or president's rule. This is imposed when a state is actually violating the constitutional provision, is actually going against the constitutional mandate. And third, financial emergency is declared under Article 360 of the Indian Constitution, especially when the financial stability, or let's say the credit, money, revenue of India is under threat. Now, please remember, this has been used many times in our country. This has been used three times, and financial emergency was never imposed in our country, was never used, never imposed. Even during the 1991 financial crisis, financial emergency was not imposed. The question now, what is the procedure to proclaim an emergency? One, the proclamation must be approved by Parliament within, by both the houses, Lok Sabha and Rajya Sabha, within 1 month. By both Lok Sabha and Rajya Sabha. The second condition, once approved, the emergency remains in effect for 6 months. We have already discussed this point yesterday. It can be renewed for any length of time, subject to renewal after every 6 months. Every 6 months, it has to be renewed with the Parliament support. And let's say if the Lok Sabha is dissolved during this period of 6 months, then the proclamation continues for 30 days, 30 days after its reconstitution, that is after the Lok Sabha is elected. Then fourth, a special majority, that is majority of the total membership and 2/3 of those present in voting is required for approval, which means special majority is required for approval. Fifth, now the president can revoke the emergency anytime without requiring parliament. Who has the power? President. No support, or without any parliament support, the president can also revoke national emergency. The Lok Sabha can also end the emergency by passing simple majority. So, for approving it requires special majority, to revoke it requires simple majority in the parliament. Now, given that emergency was misused in the year 1975, many changes were brought in, especially through the 44th Amendment Act of 1971. Now, one reform, we are discussing the reforms. So, the first reform that is required is written recommendation by the cabinet. Now, in the year 1975, the cabinet did not even know that emergency was imposed in the country. This was the power of Indira Gandhi. That's the reason it is important that the cabinet writes a written advice to the president. Then fundamental rights. The fundamental rights under Article 20 and 21. 20 and 21. 20 talks about right to life and personal liberty. Protection in criminal case, Article 21. It remains enforceable, which means this will never be suspended even during emergency protection. Then another reform that was with respect to right to property. Now, right to property was removed as a fundamental right and it was made a constitutional right under Article 300 of the Constitution. Then the extended term of Lok Sabha during emergency, that is from 5 years to 6 years, was revised and was restored to 5 years. Initially, it was increased to 6 years. It was restored back to 5 years. And under Article 275A of the Indian Constitution, which allowed the center to deploy armed forces in states during the law and order crisis, was also revoked, was taken away. And then the power of judicial review. The declaration of emergency, right, uh, was not to be reviewed as per the 42nd Amendment Act. And as per the 44th Amendment Act, the judicial power was restored, which means dispute regarding elections to the president, vice president can also be looked after by the Supreme Court. All in all, the 1975 emergency, right, was a turning point in India's democracy. It was declared in the name of internal stability. It led actually to the suppression of the political opponents. It led to more and more centralization of power, which actually goes against the constitutional mandate. And then the 74th or the 44th Amendment Act, it actually, it undid all the changes made through the 42nd Amendment Act and ensured the reforms brought under the 44th Amendment Act ensure that the emergency powers cannot be misused by the central government. And this brings us to the last topic of the day, which is the formation of new state. Now on June 2nd will be celebrated as Telangana Formation Day because this year, 2024, marks 10 years since Telangana officially became the 29th state of India. It got separated from Andhra Pradesh under the Andhra Pradesh Reorganization Act 2014. And Hyderabad was declared its capital, which capital of the state. Now, again, this pertains to the power of parliament, and when it comes to power of parliament, questions can be asked as it was asked in the year 2012. The question is, what does a constitution say? Constitution say about creation of new state. The formation of new states is governed under Article 3 of the Indian Constitution. States can be formed under Article 3 of the Indian Constitution, which means under Article 3, who has the power? Only the parliament has the power. The states do not have the power. Parliaments have the power to, one, create a new state by separating territory from an existing state, like the way Telangana was created. Merge two or more states or parts of them and create one unified state. Third, alter the boundary area or name of any state. So it can increase the area of state, decrease the area of state, right? And it can also rename any state. Who can do it? Only the parliament can do it. The states cannot do it. But in order to make changes, the parliament has to pass a bill in the parliament. But before passing the bill which is proposed to, let's say, make changes with respect to any state is sent to the concerned state, which means, one, the concerned state is also concerned, that is asked, and the, let's say, for example, change has to be made with respect to renaming the state of, let's say, Uttar Pradesh. Then the bill has to be sent to the Uttar Pradesh legislature and there is a fixed time to give, which means the bill is sent, let's say, to get the opinion of that particular state. Doesn't matter what opinion a state or states give, parliament is not bound to follow them. Parliament can also override the suggestions given by the state. The law for reorganizing states can be passed through simple majority, no special majority is required. It will be considered just like an ordinary bill which requires ordinary legislative process, and it does not require the Constitutional Amendment Act. This is something that you need to remember for your examination, right? Let us try to understand the historical background of the State Reorganization Act of 1956. Now, the states that we get to see currently or presently was not the same during independence, but the demand to reorganize state, it began immediately after independence. For example, in the year 1953, Andhra Pradesh became the first state to be created based on linguistic identity. So Andhra Pradesh, on the base of language, first state that was created in our country was Andhra Pradesh. And this decision actually led to national demands for reorganizing states on the basis of language, And in order to check the feasibility of reorganizing states on the basis of language, several committees were created to examine how states should be reorganized. For example, S.K. Dhar Commission was appointed in the year 1948. This commission recommended reorganizing states on the basis of administrative convenience. Administrative convenience. And it strongly rejected reorganizing the state on the basis of language. Then JVP, Jawaharlal Nehru, Vallabhbhai Patel, and the third person was Puttapi Sitaramaya. Even this committee rejected the reorganization of state on the basis of language, and it actually prioritized national unity. But finally, the Fazal Ali Commission in the year 1953, it actually accepted language as a basis for reorganization, but it actually proposed four key principles for reorganizing. One, the first and foremost, was national unity and security. Second, linguistic and cultural homogeneity, which means language was considered to be the basis for reorganization. Third, financial, economic, and administrative viability. And finally, welfare of the people, which means all these four criteria should meet, and not language should not be the only factor. All these four factors should be considered. All these four factors should be considered, and based on the recommendation, the 7th Constitutional Amendment Act 1956 led to the creation of 14 states and 14 states plus 6 union territories. 6 union territories. Talking about the judiciary, or how the judiciary viewed the reorganization of states. Now, in the Berubari Union case of 1960, this case is very important when it comes to reorganization of states. Here, the Supreme Court clarified that the Parliament's power under Article 3 does not include to cede a territory, let's say, to a foreign country. Why? Because Berubari in the state of West Bengal, this a part of this region was actually in the land exchange, let's say, agreement. This a part of this region was given to Pakistan. Was given to Pakistan. The court said that any transfer of Indian territory to another country is possible, but for that simple, not simple, but constitutional amendment is required. Yes, of course, the parliament can transfer a land as part of the international agreement or exchange of lands. The parliament can do it, but it requires constitutional amendment under Article 368 of the Indian Constitution, and that's the reason, in order to effect the transfer of Berubari Union to Pakistan, the Ninth Constitutional Amendment Act was passed in the year 1960 to legally transfer the land to Pakistan. Now, Even today, many regions continue or many states continue to demand separate statehood. Many regions, not states, many regions, it continues to demand separate statehood because of many reasons. One is linguistic identity. Now, states like Maharashtra and Gujarat were, created to actually reflect language-based identity, and there are many, you know, many regions. Let's say in the state of Uttar Pradesh, in the northeastern states that are actually demanding statehood. For example, Ladakh is a region that is actually demanding statehood. Then talking about regional disparities. Now, regions that feel economically neglected, like for example, Vidarbha in Maharashtra, or let's say Kutch or Saurashtra in Gujarat, they demand statehood for better development. Cultural and ethnic identity. Now, communities, especially in India's northeast, for example, the Bodos of Assam, they want a separate state. Why? So as to protect their cultural and ethnic identity. When it comes to administrative efficiency, right? Some states believe that smaller states, it ensures it results in better governance. For example, I think it's Harit Pradesh. Now, Harit Pradesh is a state, is a proposed state carved from Western Uttar Pradesh, and many people actually support this idea of Harit Pradesh. This Harit Pradesh belongs to the Western UP. And then talking of the tribal aspirations. Now, again, this deals with the northeastern states, members of, let's say, the Bhil tribe, right? They have demanded a new state called Bhil Pradesh, consisting of parts of, let's say, Rajasthan, then we have Gujarat, Madhya Pradesh, and Maharashtra. So these are the reasons why many regions in our country are demanding separate statehood. Now, please remember, the formation of new states in India have always been a a mixture of emotional, political, and also administrative factors. Yes, the constitution provides a clear procedure. The challenge lies in how the central government parliament balances national unity with regional aspirations, because in a federal country as India, it is very important to consider the regional feelings as well. Given the way Telangana was created, right, there are demands coming from various regions, and it is important to see how the parliament, the central government, balances national unity with the regional aspiration. Here it is important to ensure that the central government takes, or parliament ensures, that the reasons why the regions are demanding separate statehood should be taken care of. For example, there is no development in Saurashtra region of Gujarat, so the care has to be taken to ensure or to extend the benefits given to a state to Saurashtra, so that the reason for such demand, it ceases, it ends. And this marks the end of the seventh topic that that we were expected to discuss. Since I expect you that you have understood all the seven topics that we have discussed today. Make sure, again, I request you to please download the link of the notes of the topics that we discussed from the description. Make sure you're clicking on the link, downloading, and make sure you're revising the topics that we discussed. We are putting great effort to bring these topics to you so that you benefit immensely and ensure your success in the prelims examination. That's the reason we request you to please support our initiative by liking, by subscribing our channel and sharing it to as many needy aspirants. Make sure you revise the topics that we have discussed, and let us wrap today's session on this note. Tomorrow we'll be starting with a new theme and the topics under it. On this note, I'll call it a wrap. Thank you so much for watching.